Any additional witnesses for the defense?
No, Your Honor.
We'll move into argument. I will hear from the defense first. Mr. Couturier.
I have 1 moment.
Sure.
Need 1 moment.
Which one do you want first? Booking?
Yes. Your Honor, I have 2 documents that I'll be relying on that were submitted in conjunction with the sentencing memorandum that'll be utilized.
All right. Do you want those marked and receiving the evidence, or how do you? They've already been.
They're
part of
Exhibit 14 to the sentencing.
All right. All right. So they've already been received.
Get off the picture.
Just right there?
Yep.
Oh.
Your Honor, you've heard a lot of testimony and victim impact statements today. We're here because Mr. Pearson entered pleas of guilty to the charges before the court, and he's taken responsibilities for his conduct. And the court's in the unenviable position to sentence Mr. Pearson. But sentencing in a courtroom does not fulfill the purpose of vengeance. It's to impose punishment, a just punishment. And in doing so, the court doesn't take into account just the facts and circumstances of the case, or the crime, but also the characteristics of the defendant in fashioning that just sentence. And this is a situation where there's a young man, barely an adult, that in the fallout from a relationship with his girlfriend was extremely broken. And it's tragic. It is absolutely tragic what happened. Mr. Armstrong, Ms. Roge, and most certainly Ms. Schemitz didn't deserve this at all. They didn't deserve to have this visited upon them at all. And we know that there's going to be punishment imposed for the crimes that are before the court. But the question becomes, what is the just punishment? And so comparing the horrible nature of the crimes against the characteristics of the defendant, and to borrow federal parlance, to impose a punishment or a sentence that is sufficient but not greater than necessary to fulfill the purposes of sentencing, we have to take into account the characteristics of the defendant. And in doing that, we look to his life in total. And when we look at that life, but for the day of the events, he has lived a good and honorable life. This is a case with the media sitting here in our courtroom that's had press releases and media attention for the last year and a half. It's also a situation where many members of the community would treat Mr. Pearson like a pariah. But that's not necessarily the case here. I've been in cases of similar nature where no one will step forward, maybe even parents, on behalf of their loved one. Not this case. In this case, not only Mr. Pearson's family members, but members of the community 26 in total have submitted character letters on behalf of Mr. Pearson, in addition to the members of his family. And they all echo the same sentiments. You've heard from Mr. and Mrs. Pearson, Spencer's parents, and he has the rest of his family in attendance here today, as well as members of the community that are here to support him. And they've submitted letters to the court. His sister McKenna, who's a student at the University of Florida, writes that he was always exemplified his gentleness and his love for animals, especially dogs, and he is constantly looking out for our youngest brother, Rhett. Spencer has always had such a good heart, and he was so empathetic for people who would get picked on. She would often overhear parents complimenting Spencer's manners, politeness, and how good he was with younger kids. He was caring, intentional, and kind. His younger brother, Rhett. Spencer was there for me to hang out with and offered a helping hand whenever I needed it. That's from a 14-year-old. His older brother, Colby. Although externally Spencer may seem quiet and reserved, for those of us who know him more closely, he is one of the most kind-hearted people out there. And he concludes his letter with, "Our family is committed to being there for him every step of the way, ensuring that he has the love, support, and resources needed to succeed." Those are his immediate family members. All. And there's myriad other letters from the rest of his family, extended and otherwise. But there's also letters from members of the community that are willing to put their name out there to support Spencer Pearson, because they knew what kind-hearted kid he was. A former football coach, Todd Fordham, coached him in Pop Warner and as well as his middle school days. Spencer was a vital part of the teams he coached and the success we had a team. Spencer was always a great listener, willing to do whatever was asked of him as a player. Spencer worked diligently to be the best player he could be, while always making sure his mindset was team first. Another coach at his high school, Eric Henkel. While as coach, Spencer was always shy, reserved, and respectful. I do not recall Spencer ever getting agitated, disrespectful, or aggressive towards his coaches or teammates, nor angry in any way during those years I coached him. And Mr. Coach Henkel noted the change that Mr. and Mrs. Pearson testified to his junior and senior year. And he states, "This passive and shy personality is why the events of this last year were a tragic surprise to me. His purpose is to let you know that his actions last year did not seem to be characteristic of the young man he knew, and he hopes that whatever you, Your Honor, decide, he is able to receive the help he so obviously and desperately needs." A family friend of the Pearsons who knew Spencer well, the children were of her family and the Pearson family were all of similar age, and they spent a lot of time around not only the parents but all the families. Sarah James states, "3 of our 4 children are the same ages as the Pearson children. We have spent time together on family trips, evening meals, and worshiping together on Sundays in church. Spencer never demonstrated any aggressive behavior, and I observed him to be normal, kind young man. He was always welcome in our home." On one vignette, if you will, regarding the character of Spencer Pearson. Last year, during one of his daughters, during her freshman year, there was a Hope class at Ponte Vedra. Spencer's weightlifting class was often in the gymnasium during the same period as her child. He always made a point to come over and say hello to her daughter and ask her how she was. This brought her comfort because she did not have any of her close friends in that class, and having a familiar face brought her joy. Lastly, I'll reference, and there's numerous other letters. I'm not reading them all. The court has them and has read them. But another coach of Mr. Pearson, Jermaine Swafford, writes, "Throughout my time as his coach, I came to know Spencer as a well-mannered, respectful, and disciplined young man. He was never one to cause trouble or show disrespect towards his teammates, coaches, or anyone else around him." Coach Swafford fully acknowledges the seriousness of the situation Spencer is facing, but I also know the good young man that he is and the potential he has to grow and learn from this. I have always seen the Pearson family as kind and supportive, and I believe with the right guidance, Spencer can get back on the path to becoming a responsible and contributing member of society. That's the members of the community that know Spencer, and that's the Spencer he knew, not the surveillance video from June 3rd, 2023. So when we see that video compared to the character that is known to be that of Spencer Pearson, the question is, how could this happen, this tragedy? These three innocent people that deserved nothing in the way that they were served that day. How did this come to pass where Mr. Pearson engaged in that conduct? And you've heard a lot of testimony today. We know that he was a good kid in elementary school and as a young man, had social anxiety issues from a young age. But he's been described as peaceful, gentle, and kind, with the exception of the day's events. And over the course of time, that condition became progressively worse. It worsened in high school, when we know that he started to decline in that regard in his junior year. And after the breakup, we know that his mental health certainly declined. And the Pearson family was desperate to get help for their son. So, in doing so, they're reaching out to all avenues available to them. Licensed psychologists and practice groups weren't able to see him. And we've discussed the difficulty in accessing mental health care, particularly for youth and particularly on the backside of the COVID pandemic. And you've heard the testimony here that people could not take him. It was 3 to 6 months. And so they were desperately trying to get help for Mr. Pearson in any way they could. And they find this organization here tomorrow who could see him immediately. And when you look at the records that are contained in the sentencing memorandum from here tomorrow, there's a breakup in April. And at this point in time, Mr. Pearson's in an extremely depressive state. He didn't go to prom. He's not going to school, and is living on the couch, not eating, not doing well. The family's desperate, and they're reaching out for help. So Spencer here tomorrow could see him immediately. So he goes on April 13, 2023. And he talks with the peer specialist or friend, not a licensed therapist, not a psychologist, not a psychiatrist. And although he has contemplation of thoughts of suicide expressed to this peer specialist, the treatment regime exists of emotional support, information, and listen. And I don't question the motives of here tomorrow to try to help people in distress, but the magnitude of this problem, they were not equipped to address, not without licensed practitioners. And so unsurprisingly, 4 days after that encounter, Mr. Pearson attempts to hang himself. We've heard the chilling testimony from his father about having to recover his son and lift him up to take pressure off of his neck from him trying to kill himself. He was that desperate and that low, in such a low place, that he wanted to end his life as an 18-year-old high school student with no abusive background in his family. No physical abuse, no sexual abuse, none of that. But here's a young man that's supposed to be in his salad years, if you will, that is so despondent that he's taking his own life. After spending the night on the couch with Mr. Pearson, his mother and father, after reaching out to some friends that were in the medical profession to get referred to Baptist Hospital, take him down there the next morning, where he's admitted for 5 days. And they're saying, call on Monday, and we need to get him put into outpatient therapy. Well, Ms. Pearson does that, and there's no room at the end. we don't have space available for Spencer. So they're right back in the same dilemma that they were before he attempted to take his life, and trying to get the resources to help them. But once again, when the phone calls are made, we don't have room for him. We can see him in 3 to 6 months, and they can't get him into therapy. And he languishes on the couch. And this is Mr. Pearson's first serious battle with an acute mental illness that is now manifested in a suicide attempt, and that no one can see him other than emergent care, where he's admitted for 5 days in a hospital emergency situation. But when left to your own devices outside that milieu, there's no room at the inn. Now, they had never been in this situation before. Spencer had never been on medication. He had been given medication at the hospital, but when he was discharged, he started experiencing side effects, headaches. He didn't like the way it made him feel. And not having been through this, and without the guidance of medical professionals to go through it, Spencer discontinued his medication. And he, once again, spiraled downwards into a despondent state of severe depression. Witnessing this reoccurring again, Mr. and Mrs. Pearson, having no available resources to him, go back to Here Tomorrow just because he can be seen. And he's seen on May 31, 2023. 4 days prior to the date of the events that bring everyone to this courtroom. 4 days. Spencer recounts to the peer specialist that he attempted to commit suicide. He had concrete plans. He had ideation. When you look at the progress note that was filed as, I believe, notice of filing number 8, the last one that was filed, it states his current status was now preparation. Before it was contemplation. Now it's preparation. And they know that there's been a prior attempt. The course of treatment that was ascribed to by that entity is to make a safety plan. But the safety plan is to be made the next week with a young man that Al has preparing to commit suicide. He returns home, and 4 days later, these heinous crimes are committed. And so, in the course of the events, Mr. Pearson, after committing the horrible acts that numerous people have discussed here today, takes the blade and turns it on himself. Several times, slowly and methodically, slicing across his neck. And before the court, and this is exhibit, I believe, 14 of defendant's sentencing memorandum, you see the grievous injury that he inflicted upon himself. This was the state of despair that Mr. Pearson was in. And I don't mean to discount the harm and the suffering and the injuries of the victims. I recognize that. But Pearson is a damaged kid. And this is evidenced by this photo that is so deep, where he's lacerated his trachea as well as all of the other organs in his throat. And it's remarkable that that suicide attempt did not succeed. Because when the rescue responded, and you have the fire and rescue records before you, on the Glasgow coma scale that goes from 1 to 15, 15 being fully functional, 1 being near dead, he was a Glasgow coma scale of 3. He was not breathing and barely had a pulse. They were able to intubate him and save his life. Like Ms. Schemitz, he was life-flighted, but to a different facility, UF Health, Shands in Jacksonville, where he underwent extensive surgery over a number of days before ultimately during which he was arrested, and he hasn't seen his family ever since. The only contact he's had with his family is through a tablet. And when he's released, he wears the scar on his neck as he's in this booking photo. And he still has that scar as a reminder to himself, as well as the rest of the world, about how damaged he is and was. And so how does that come to pass? Well, we know that Spencer played tackle football from age 6 to 18, 12 years, and you've seen a brief video clip of it. But before I get to that, we've got a young man, barely above the legal threshold for a juvenile. And the law sometimes draws arbitrary lines, and I would submit that the age of 18 at majority is an arbitrary line. As Dr. Rubino alluded to, we'll go give a young man a gun and send him to a foreign land and serve as cannon fodder for our military, but they can't drink a beer. We don't trust them to drink a beer or any liquor, but we can give you a gun and send you into battle. Is he an adult at 18? Well, the science regarding the brain suggests not. And this science has now been well established and litigated through courts from the bottom to all the way to the Supreme Court on numerous occasions. And through the science, which we heard from Dr. Kropp as well as briefly from Dr. Rubino, we know that the adolescent brain is not developed at age 18. Far from it. It's just starting to finish its pruning and myelination. And that continues in that process from shedding gray matter into white matter to get executive functioning. Doesn't happen until 24 or 25. 6 years removed at a minimum from where Spencer was on the day of the act in question. And why is that important? Because that controls the executive functioning or guides the executive functioning of a young man's brain. They lack impulse control. They act without regard of consequences. There's poor planning. They don't think of things with forethought. That's why they make good candidates for combat soldiers. And so we have this young man with an adolescent brain that isn't fully formed, that doesn't have the capacity to engage in the critical decision-making and judgment that's required to proceed through life, is a starting point. That's across the board for all youth. Kids are different. And although he may have been 18 and legally adult, he's a kid. He's a kid as he sits here today. And so layered on top of the youthful brain, we've heard from Dr. Rubino, who had the occasion to view images of Spencer's brain. And what did those images tell us? That this kid has been the subject of repetitive head injuries for 12 years. By his dad's count, and I would submit it's very conservative at 15 a session, 10,000 hits to the head. Some more serious than others. In that video, we saw a 300-pound plus kid smash his head, buckle him, and I would submit he was concussed at that point, and then pancake him. Because of the nature of the game, Spencer gets up, has head-to-head contact of significant force with the quarterback. 2 concussive events in one play. Not to mention the myriad other events. We know he was out in concussion protocol at least twice once that developed, but they didn't have it in middle school. They didn't have it in Pop Warner. Hopefully, the kids aren't getting injured. But when Dr. Rubino looks at Spencer Pearson's brain, we know there's a lesion on the right frontal cortex that's in an area that's inconsistent with any vascular source, not to mention that he's 20. He hasn't had time to develop those problems. There's no indicia from health records or otherwise that he has any vascular problems. But he's got a lesion on the front part of the brain. He's got the cavum septum pellucidum. the separation of the two hemispheres of the brain and the membrane, that with a 20-year-old kid with no other explanation, who's played 10 years of tackle football, the only explanation is head trauma. We know about the cingulate gyrus being impaired. And why is that important? Because that is part of a brain and a human's limbic system. And the limbic system, once again, controls emotional regulation, poor judgment, impulse control. All of the same issues that are inherent with an adolescent brain as a starting point are exacerbated for a young man with the injuries noted in his head. So when you combine the two, they compound that problem. And the lack of emotional regulation and impulse control and judgment is even worse. We also know that he's working on a significant neck injury, cervical stenosis of his spine. It's going to get progressively worse without medical intervention. And if it doesn't, it could result in him being paralyzed. And the irony of that is not lost on me. But as that is not an appropriate punishment to be doled out in a courtroom. But that's what he's looking at without treatment. And the court's been around a long time, as have I. And the court is aware of the medical treatment that's rendered in the Florida Department of Corrections. It's less than stellar. That problem will not be addressed. So on top of the organic brain injuries that exist and the brain damage, we have the psychological component. Dr. Kropp spent over 18 hours with Spencer between testing, interviews with him. And what do we know from that? He suffers from major depressive disorder and social anxiety disorder that further impair his judgment, his impulse control, and the other matters that are just getting compounded and compounded and compounded on top of one another. In those psychological issues, coupled with the adolescent brain and the brain injury, caused this young man to act impulsively, without regard to consequences, without judgment, planning a forethought. And tragically, it resulted in 3 people unnecessarily being stabbed, significantly injured. And it breaks my heart to hear this young lady suffering for this the rest of her life, not to mention the trauma of Mr. Armstrong and Ms. Roge that will likely be dealing with their injuries and their psychological injuries for the rest of their lives. I recognize that. And for that, my heart breaks. Dr. Kropp also found him to suffer from autism. And I've spent a lot of time with Mr. Pearson myself, and I'm no expert, but I tend to concur with him, having spent days with the young man. And you layer that facet on to the others, and it may not have the same features of impulse control and poor judgment as the other issues that Spencer's experiencing, but it certainly doesn't help. So when we're looking at the overall background of the defendant in fashioning an appropriate sentence, and not just seeking vengeance, as many in this courtroom would like the court to do, that is not the job. The job is to impose a fair and just punishment. And I would submit to the court that even though the statutory max in this case is life, this case is wholly inappropriate for a life sentence. This young man is not irredeemable. He does have a potential for a future. He's got a supportive family and support network that can help him going forward and ensure that he's never in this position again. He recognizes the gravity of this situation. He's remorseful, genuinely remorseful for what he did. there's a future for him if he's permitted to have one. And I think life is wholly inappropriate. And I submit a guideline sentence of approximately 20 years is inappropriate for a kid with the injuries that he has and the conditions he's suffering that are documented, replete with multiple attempts to take his own life, the scars of which he wears today. We've moved for a downward departure from the sentencing guidelines. I believe we satisfied each and every one of the departures that are sought. His capacity to conform his requirements to the law substantially impaired by the injuries he suffered to his brain, the adolescent brain, as well as the serious psychological diagnoses he's had that impair his judgment. He certainly requires specialized treatment for a mental disorder, and it's unrelated to substance abuse or addiction. You've heard no testimony that he has any of that. It's absent entirely from his background, other than a high school kid that may have had some beers or seltzers on an occasion. But this kid's not an addict. He's not a boozer. His problems are mental health and mental health alone, except for the cervical neck stenosis or cervical spine stenosis, which is a physical disability under the departure. And we know he's amenable to treatment. He's been on medication ever since he's been in the jail. We know he can reject that if he so chose, but he's now recognized that he needs help, and part of that help is medication. But there's other facets of treatment that would benefit Spencer, for which he is amenable. Therapy. Dr. Kroc recommended therapy 2 times a week individually and group throughout to help him overcome a social anxiety disorder. And he wants the help. He just asked you for it. His family's been screaming for it. And so he meets the basis for a departure for specialized treatment for which he's amenable. We've also sought one for the crime being committed in an unsophisticated manner, an isolated incident for which he shows remorse. As tragic as what we've seen here today was, it was unsophisticated. There was no, this wasn't a white-collar fraud case. This isn't multiple drug deals. This isn't trafficking. This isn't the normal grist for the mill that the courts encounter and defense counsel deal with. This was a instantaneous attack. So it was unsophisticated. It was isolated. He has absolutely no criminal history. Never been in trouble with the law prior to this. Never been violent to anyone prior to this. And he's shown remorse. And lastly, we're seeking a departure on the basis that the defendant was too young to appreciate the consequences of the offense. And in doing that, age alone doesn't cut it. I'm aware of that. But emotional immaturity coupled with chronological age, and this isn't somebody that's 20, 22. We're talking about a kid 9 months removed from his 18th birthday. So, and Dr. Kroc testified that due to his psychological conditions, as well as the adolescent brain, he is emotionally immature. And so we've met the grounds for that departure as well. Now, I know the court, in whether to grant a downward departure, it's a 2-step process. One, the court has to determine whether the defense has met the burden of production by a preponderance of evidence to satisfy the grounds for the departure. And I submit to the court we absolutely have. But the second one is discretionary. The court has to decide whether it thinks departing will provide for a sentence that is appropriate. It's a discretionary act by the court. And I'm imploring the court to exercise that discretion because this kid is damaged. This isn't an incorrigible criminal. This is a broken kid that is not irredeemable. He has a chance in the future if he's offered the opportunity. He's willing to accept the help. He's been doing it ever since he's been incarcerated. He has a support group that will help him stand up in support to help him get that help. And I'm firmly committed that if Spencer is released, and there's, in addition to incarceration, there's other facets of punishment that can be imposed. The court can put him on supervision. He can be on community control for up to 2 years. He can be on probation with a court order requirement to maintain treatment and have treatment providers report to probation to ensure that he's following through, not to mention the people that want to give him help and his own desire to get help. There's ways to fashion that sentence. And further support for a mitigated sentence is the pre-sentence investigation itself, prepared by a member of the Department of Corrections, that in the recommendations doesn't make a recommendation as to the sentence. That is the unenviable task of this court, and I do not envy the role. But in the report, the representative of the Florida Department of Corrections is recommending to Your Honor that when he's incarcerated, that he go to a facility that he can get specialized treatment for his disorders. Now, I'm not aware of any such facility in the Department of Corrections, so I'm not sure that, as much as everybody wants to have that happen, that it's even available. It sounds good, but in practice, it doesn't exist. You get pills, and that's what you get. And so respectfully, for this kid that prior to this horrible event that we view today has lived an outstanding life. He goes to his neighbors to help protect a wife and daughter while the husband's out because they think there's a burglary. He's helping neighbors, elderly neighbors, not climb ladders so they can put lights up around their home. When an elderly gentleman got into a car accident out on the road in front of his neighborhood, Spencer rode out there and assisted the old man and made sure he was okay. This young man has empathy. He's not a sociopath. He does care for other people, as testified to by all of his family and community members that have stepped forward with support. He's not an incorrigible criminal sociopath. It's a kid that has a chance if he's offered the opportunity. And so respectfully, Your Honor, we're seeking this court to impose a sentence that's significant. He's 20 years old as we sit here today. I'm asking for the court to impose a sentence of 12 years. He doesn't have 2 years in time served yet. He'll be at 30. If the court imposes that sentence, he'll be 30 or so by the time he gets out. His salad years, the 20s, the best years of all of our lives, will be spent incarcerated in a gladiator camp. That's a serious sentence. And maybe we get numb to the amount of time that gets doled out in these courtrooms. You hear these decade-long sentences, right and left. And some people are deserving of it. They've had opportunities and they've blown them. This kid's never had the opportunity. Not in the criminal justice system anyway. And so he's deserving of a chance. This isn't a life case. I submit this isn't even a 20 years case. A decade in prison for this kid in his entire 20s is a severe and significant sentence. And it is just punishment. And so we're respectfully submitting to the court that an appropriate sentence in this case is 12 years incarceration, followed by 15 years of supervision with the first 2 years of community control, thereafter with probation, to order mental health treatment and counseling, obviously no contact with any of the participants in this case, but to get the help he needs to become a productive member of society, to prove that he's not the kid that we saw in this video for 20 minutes, that he is the kid that the rest of his life has demonstrated, the one that his coaches are willing to step up for, that his family sits and supported behind him, the community around him sits and supported behind him. He is redeemable, and we're asking for that opportunity, Your Honor. Thank you.
Thank you, Mr. Kachergis. State.
Your Honor, counsel started by describing the good character letters submitted on behalf of the defendant. We've heard the testimony today, and I have no doubt that a lot of that information is very, very true about the defendant and his growing up and him as a child and all of those things. But you also have to think about his characters and his characteristics that came out when he was in this new type of relationship. This isn't his mom, this isn't his dad, cousins, neighbors. This is that intimate dating relationship, that future romantic relationship that he may have. And what came out about Mr. Pearson that perhaps nobody had ever seen before was an individual willing to stalk, harass, scare, wanted Madison to feel his pain. That's why he sent the picture of him about to hang himself. He told Dr. Kropp that on that day, one of the reasons he was going to kill himself is because he wanted Madison to live with that guilt for the rest of her life. And I understand he's a depressed individual, and I understand he suffers from social anxiety. But those characteristics are dangerous for the future of this individual in any relationship like that he's ever in. Now, the threatening message he sent just 6 days before on its face may not appear that threatening, but to Madison it was. You heard everything that had gone on, and he knew everything that he had done up to that moment. And so if you saw that message in a vacuum, you might be like, okay, maybe this is a kid joking around, but you heard everything she went through. And so to her, at the end of May, when she saw that, that was scary. You're going to get yours. And sure enough, 6 days later, when he saw her, he took that opportunity to try to hurt her, to try to make her feel pain. Maybe before that, all it was emotional, and he never had thought about hurting her. But as soon as he saw her that day, as soon as he walked into that restaurant, noticed her, sat back down at his table, watched her get up, sat there, you saw him stare out the front of the windows. He was waiting until they were done talking to that staff member. He was waiting for them to walk away, and he sat there and he cracked his knuckles and he rubbed his hands on his shorts where his knife and his sharpening block were. And even if you believe that he didn't know Madison was there until he pulled into that parking lot, maybe he saw her car as he drove by A1A, maybe he didn't. But when he drove in that parking lot, it's very clear. There is no reason why he moves his truck unless he sees her vehicle and he wants to park next to it for the opportunity to see her in some fashion. It makes no sense otherwise, and it makes no sense that he doesn't recall why he did that when Dr. Kropp asked him. So he knew she was there, and he stared and he waited, and certainly the intent to hurt her was going through his mind as he was sitting there and before he ran out. And so I understand with one of the downward departure grounds, unsophisticated, he has shown remorse, this level of violence is isolated. But Your Honor knows, stalking, harassing, putting in fear only leads to violence. We all know in this courtroom that's what comes next. And it did. This wasn't an individual who was otherwise normal and got into a random fight in the Chubby's parking lot with a stranger and ultimately ended up hurting them. No, that would be an isolated, random, violent act. This was someone he was emotionally attached to who had escalated his behavior towards her. So those characteristics need to be considered too. Not just who he is, not just who he was as a child, but that person that he was when he was in that attachment type relationship with his mental health. Now, we all know DOC is full of persons with mental health. That's not it's a downward departure reason that someone may need treatment. But DOC is full of individuals with mental health problems, unfortunately, far more severe than Mr. Pearson. He's not psychotic. You're right. He's not psychotic. He knew what he was doing. All the doctors state, Dr. Kropp, he's the one that would he didn't even need scans. He didn't even call for them. But what is in the scans, we heard about it ad nauseum, but at the end of the day, it has to do with potentially Mr. Pearson's future and some physical issues with him. But at the end of the day, Dr. Kropp, before he even knew what was wrong with his brain, said, this gentleman has no impairment to his executive functioning, which is the frontal lobe. He is a normal adolescent brain. He's an adolescent brain, no doubt. We're not dealing with an older gentleman. No cognitive disorders, no impairment to his executive functioning by any of his neuropsychological tests. He is suffering. He is depressed. He has social anxiety. There's a lot of people in America that have depression and social anxiety, and there's millions of young men playing football who do not stab and try to kill their girlfriends. So I understand they're presenting this to you and mitigating, and they're telling you about who he is and what he suffered through. But there's been no correlation to why that is the reason why he did what he did, as if it would be an excuse anyway. So what should you do, Your Honor? Mr. Kuchergis is right. Sentencing is not about vengeance. It's about punishment, but it is foremost about punishment. And you are to weigh this defendant's background into that. And so when you think about what should you do? Well, if Miss Rogé and Kennedy Armstrong were not there, he would have kept stabbing her. She would have died. Mandatory life. Wouldn't have mattered. 18, 19, 20, it wouldn't have mattered. He failed to do that. And so, no, we're not here on a homicide case with one grieving family for the ultimate loss of one person. But we're here with 3 people, 3 separate victims, injured in the most horrific way that will deal with this, Madison especially, physically for the rest of her life, emotionally for the rest of her life. Her mother now is dealing with her own physical trauma, emotional trauma, and of her daughters. And then you have Kennedy Armstrong. You saw him up there. His demeanor. His injury is minor. His physical injury is minor in comparison to the others. But he has been through trauma. It's very clear. And he will have to deal with that as well. So you have 3 victims that will live with this for the rest of their life every day. And Madison, she lives with the fact that every new person she meets, she knows. They don't even have to say it. They don't even, ask her. She knows they're probably thinking, what happened to this girl? Every single person Madison meets for the rest of her life who sees any sort of physical disability with her will wonder. And she will know that as she talks to that person. So every single moment of every single part of her life, she will think about June 3rd. And so you have to think about the fact that there are 3 victims in this case. What would you do if this was just an attack against Madison? What would you do if Madison, her mom, were there, but the defendant only attacked Ms. Rogé and you had the injuries that you had in a similar circumstance? What would that be? What would that punishment be? And then what would it have been had he never got to Madison and her mother and Kennedy stopped at first but got the injuries he did? This is a single incident, but it's 3 victims, and technically under the law you can run all 3 counts consecutive. But you should think about the punishment that you would apply in each individual scenario. And I submit to you that it's not a life sentence. It should be a lot of years in prison. They will suffer for a lot of years. I spoke to the one downward departure element judge. The youthful age, the other one, he does not appear to appreciate the consequences of his actions due to his youthful age. We know he's youthful. However, even Dr. Rubino said he could. And Dr. Kropp said he could. He could conform. He knew. We knew he did because he outlined his plan that morning to Dr. Kropp. He had a complex thought process of where he was going to go. If you believe that to be true, what he told his doctor, Dr. Kropp, that he intended to kill himself that day and nothing else. That whole process was complex thoughts. I'm going to go to the beach so my parents can't find me at home. I'm going to kill myself there. I'm going to bring a knife that has my name on it so they can identify me. And I'm doing all of this to hurt Madison for the rest of her life. He knew the actions on the morning. He had actually contemplated what they would be. So he's someone who can appreciate the consequences of his actions. And like Mr. Katurga said, even if you find that some of the mitigation has been proven, there's still that second prong. Should you depart? And absolutely 100% the state believes that this is not a case where a departure is appropriate. Not at all. All 3 victims will think and live about this trauma for the rest of their life, and he deserves to be punished for a very, very, very long time. For the pain he has put them through already, for the pain they will all remain in, all of their families. This is a ripple effect, Your Honor. And for all of the reasons stated and all of the evidence presented today, we ask you to impose a just punishment of life in prison. Thank you.
Thank you, State. All right, let me take a brief recess. I want to just think about a few things before I impose sentence. So we'll stand at recess for about 15 minutes.
That was me last.